SJC-10222, Commonwealth versus Imbert.
Mr. Sinsheimer, good morning.
Good morning. Thank you. May it please the court, my name is Robert Sinsheimer, and I represent Ludnar Imbert. Many of his family are here. He has waited a long, long time for this day and is someone who has, from day one, protested his innocence. He had some bad luck with appellate counsel early in the going. Someone retired, someone left the state, and it's taken, as I say, too long through maybe no one's fault. Are you familiar basically with the facts of the case? That if not, all right. So we know it's a shootout, we know it's a brawl in a bar that results in a shooting. A primary issue that we've raised, and I think absolutely and unequivocally reversible error, is the failure of the government to disclose exculpatory evidence prior to the first trial. And the way it has boiled down, I think, creates for this honorable court a simple issue, despite the relative complexity of the background. The simple issue is whether or not an identification procedure that includes a photograph of an alleged perpetrator, whether that procedure presented to someone who arguably could have seen the process or the events which are being questioned about, whether that procedure is in and of itself exculpatory.
So we have two witnesses, right? We have that this involves Owen, right? Crystal Owen.
Crystal Owen and Corey Crump.
Right. So Crystal Owen is sort of consistently testifies she can't identify the defendant, right?
Well, at trial, she was never really asked. And so when you say testifies, that's what I'm picking on that word, because I think technically you're right. The one thing we know for sure is she never identifies.
Correct me. I just want to make sure I understand factually.
Yeah, that's
okay.
Well,
Because the motion judge says, look, Owen doesn't identify him anyway, so she says she wasn't able to identify him, so what would this add? So address that.
Well, to me, you see, that means he didn't do it. I think you really have to step back, Your Honor.
Well, I'm not sure I follow that. I mean, I understand that she sees a man, right, with a black coat, a tall man with a black coat and a hat. I can't remember exactly. But she says she can't identify him.
Well, that's what we don't have, Your Honor. That's later on, years later. What we have is the fact that the police showed her an array. Now, they wouldn't have showed her the array if they didn't think that there was a likelihood they would develop an identification. In fact, when they do, sometimes I have to wonder, frankly, if they're just lucky 1 in 8, when I consider how poor memory really supplies identification. But the fact of the matter is, when they do and they get an identification, they can't wait to tell us that it's a conviction. So what I'm suggesting to you is this, Your Honor. Let's suppose someone commits a crime and there's one eyewitness, only one. Right. And the person who's the eyewitness says, I saw the person, I know who it is. Meaning I could identify him if I'm shown again.
And we do have that person in this case, Vic, right? Vic says she knows the defendant, she knows the victim.
And that's her 4th try.
Okay, but...
And we don't have a transcript, which is very, very troubling, and there's only so many issues I can get to in one morning, and I think we've briefed that, but I mean, that is very, very troubling in and of itself. But yes, at least on the record we have, assuming it was reconstructed with some sagacity, yes, sure, we have this statement that she could identify him. But we have, but going back to my hypothetical, you have someone that commits a crime, you have someone else that says, I've seen it, you do an array with Jones, Smith, and Brown, and the person says it's none of them. To me, that means they're all innocent. Or at least more precisely, it is some evidence that they're innocent, and it's just as good as if the person said Brown. It's just as good as it would have been for the government if they actually picked somebody. So it is the antithesis of a positive identification. And that means it's exculpatory in plain English. And that's what exculpatory evidence is. And that's why this is a narrow issue. There, in my mind, Your Honors, is no circumstance, none, where a precipient witness...
Let's assume you're right, that it is exculpatory and that the issue therefore comes down to the issue of prejudice. If the notes had been handed over, what precisely did it say with regard to what Crystal Owen said with regard to that photo spread? Did it say that the shooter is not there? Did it say I'm unable to identify? I mean, there's variations on this theme. What precisely would the notes have
Well, I have the
revealed?
notes on page 156 right in front of me. First of all, they're barely legible. What I really wanted was an evidentiary hearing. But I could tell you this. If I had these notes...
Sorry, it's volume, just...
What did,
Meaning
hit
post-trial,
156 of the appendix?
Yes, page 156, RA. It's it was also Exhibit 1H to my motion for a new trial. It's RA 156.
Okay.
And those are the notes of the interview with Crystal. There may have been a second one, Your Honor, and I may have misspoke about whether that's the page that
but
has the actual...
If this document had been handed over to you, what would you have, what would defense counsel have known that defense counsel did
Well, if I
not
had got the one with the array also, I would have done exactly, and you'll forgive me for this because this is a little extra record, but you have to forgive me because it really happened within the last month. I would have done the exact same cross-examination I did in front of Judge Bruce Henry in a case in the Middlesex Superior Court, Commonwealth versus June, where I had the witness go through the array. So you didn't pick this guy, no, you didn't pick this guy, no, you didn't pick this guy, no, and that's my client. That's how you do it. So the fact of the matter is, you got the jury looking at the client on the big screen that the government just loves, and you got them seeing he's in this array, and he didn't do it according to this witness.
Well, you still haven't answered my question as to what precisely the report of interview says as to what the witness said when shown the photo spread. Where do I find that?
Oh, I see what you're saying.
I assume you're saying that there was a report of interview and that the investigator said, I showed a photo spread to Ms. Owen.
Yeah.
And
that was even found by the trial judge, Your Honor.
what did the officer write as to what?
The exact words are escaping me at this moment, and I apologize for that, Your Honor. Remember, we're working backwards.
And you sure it's on 156? Because I can't find it on
I can't
156.
Well, that's
find
what I
it.
said. No, I'm not. 156 is definitely John Sylvia's interview with Crystal Owen. And because it says right there, Crystal and David at the Lion's Den, there's a time. I think there was a second one. If you give me a minute, I can plow through it. I had my fingertips on that one, and that. But if you want me to send a letter later on, that might be better.
Okay, well, maybe Miss Campbell has this knowing look of hers, so maybe she'll be able to help us.
163.
Okay.
And boy, do I
I know
appreciate
her
it.
knowing looks when she appears before us.
Well, the issue, Your Honor, frankly, is that I don't see it on this page either. But what I do see, and what I know is the record,
Maybe Ms. Campbell's not as knowing today as usual.
Oh, he's usually quite knowing, but we'll find out in time.
Look. Didn't okay, that's, Your Honor. And now you can see exactly what your questions may have demonstrated some ignorance on my part, but at least it's marginally justifiable because it's a note that says, looked like a photo, hard to recognize anybody. And you know, yes, I knew what it was when I first got this thing and filed for a new trial 3 years ago. And so the irony of your questions, which have just demonstrated my ignorance, is that a lawyer in my situation shouldn't be as ignorant. And I'm not talking about my lack of effort, because we've worked really, really hard on this case. I'm talking about the fact that this person's ability to flesh this out has never been drawn out, and the reason it's never been drawn out is because the government withheld it. Let's go back to why we're here. This is absolutely unequivocally exculpatory evidence that was denied my client, and despite a direct request. And make no mistake, respectfully, the trial judge, meaning the new trial motion judge, has already determined that the request was properly made and has already determined that the material was available and has already determined that the government institutionally is responsible for it without naming, you know, anybody's fault. And here it is. Can't recognize anybody. So that's all I have, I guess.
Is that what it says? It says,
Well, that's...
I don't see that that's exactly what it says.
No, that's unequal.
That
Judge.
photo, what is the fourth word?
Looked at photos and unable to recognize anybody. That's what I read that as, unequal.
And okay, whatever it is.
But your position is that, your position, as I understand it, is this is exculpatory information, and that should have been
Right,
communicated
and
to
there's more to it. And, you know, you started questioning me correctly, and I apologize. I know we're supposed to know every page.
You're very knowing, too. I don't mean to be...
No, but the thing is...
Okay, but I mean, but let's assume that in a better world, and I take your point, that when somebody is unable to recognize somebody in a photo spread, that should be furnished to the defense counsel. I get that. So let's assume that it should have happened. There should have been a letter to you or something to communicate
It was
that you
before
understood.
me. I didn't try the case.
Not you. I'm sorry, defense counsel.
That's all right.
Okay, so let's turn to the issue of prejudice. There's a reference to a tall man and to a shorter man. Is there any evidence as to whether Dapp was short and Imbert was tall?
We found the evidence confusing, and we think they're both about 5'10". We do think Imbert is taller. And, you know, I plowed through that. One of the reasons there's prejudice, Judge, is that by its very nature, this was a confusing event. So for me to respond to you with some confusion can't be helped because there's like 20 people that saw snippets. And the fact of the matter is, Vic, who is their star identifying witness, she only saw a snippet too, and she didn't see what she said she saw. But that in the light most favorable to the government, I have to give them that.
Can you explain, what was the challenge to Vic's ability, one, was there a reference to, because Vic knows both the victim and the defendant, right? Is there some evidence of bias presented at the trial regarding her? We also have the fact that the defendant calls her up and says, you don't know me and I don't know you.
That's a bad fact for my client, I can't deny it. He supposedly calls her up and says, I did what I had to do. But my evidence...
Well, he does more than that, right? He says, I did what I have to do, and then you don't know me and I don't know you, right?
I think those are the words that came out of trial.
Right.
And the reason I'm hesitating, Judge, I didn't want to use my 20 minutes on the issue of the transcript.
I think Chief Justice Gantz is going to be generous with you, I can tell. So keep going.
Well, here's the thing. I mean, we don't have a transcript. That's a whole separate issue. You have the one identifying witness in an important case, and we don't have a transcript. So I'm going by Judge Conley's reconstruction. Right. Which he himself says is from his own personal memory. There could have been a million objections.
Wait, I think he said it was from his 12 pages or 20 pages of notes.
Notes.
That's different from memory. He wrote notes during the course of the trial, I assume, correct?
Well, by that, I meant it's his and his alone as opposed to any input from the
Well,
defense counsel.
but it's not his alone, because prosecutor agrees with the notes. I understand the defense
Well,
counsel
that's a
disagrees.
shock. They-
I know, but we are sort of, and you're offered his notes, right? Defense counsel's offered the judge's notes?
Well,
It's not as if
the
you can't
defense
look at it.
counsel and the judge, that's, again, another issue. It might be a satellite issue, but when you look at the gestalt of the situation, defense counsel and the judge, I think I can politely say we're not getting along.
Yeah, and that's a whole separate argument, I
It is
understand.
a separate argument, but there's overlap, because and the last thing on God's earth I want to do is stand at the highest court of the state and suggest that there was impropriety on the part of a trial judge. I won't do it.
You won't
But-
be the first person who did that, so,
I understand, but I could have chosen to make it a reversible issue, and I didn't. I gave it a ton of thought, and we stuffed it, I shouldn't say stuffed it like it's irrelevant. We put it under the 33E rubric, because I think that's where it fits. As an ethical lawyer, an officer of the court, that's where it fits. It's clearly a 278 33E problem. When you have a judge and a defense attorney that can't get along, and then, where I brought this up is, you have this same judge who
can I get back to what I think is your core argument? I just want to understand it better. Because we have damning evidence from this person, Vic, and I just want to understand why you say she can't observe this.
Okay, sorry. I was getting to that. First of all, it's not so damning. It's damning because Judge Conley wrote it up as damning. But second of all, she sees something, she's supposedly in the car. The best evidence in the record that actually is tried, of the case that was tried, is Shakisha Warner. Because Shakisha Warner testifies that she's sitting in the passenger seat and Vic is driving, and she's supposedly observing this stuff by looking backwards. So, if I read...
Which she are you talking about? Vic is driving and...
Yeah, Warner doesn't see the shooting. Vic's the only one in the entire mess that claims to have seen the shooting.
Right.
Warner essentially impeaches Vic, and cleverly and strategically soundly, in my view, the government called Warner. So you may not pick that up, but they put her on because, and also a lot of times now in homicide trials, they just put on everybody. We all know that. And that's the way they go about doing it, and it makes some sense from a strategic perspective. So they put this lady on. She says, she doesn't say Vic didn't see it, because she can't testify to what someone saw. But she puts her in a place, and we argued that vigorously in our brief, so you can find the pages easily. She puts her in a place where she couldn't have seen it. And she, Warner herself, says, I couldn't see it, and Vic was right next to me. So right there is doubt cast on Vic. Now the other thing, and I think it's crucial, I am not standing here to argue against Vic's sincerity. I wasn't there. I know that I'm not the finder of the facts. I can't argue as to her credibility in and of itself, but I can certainly say she may have been inaccurate. And I think way too often.
Okay, but and then I get it. Can I ask you about Clayton then? Because Clayton also observes your client. He observes your client with a gun, right? Right. He hears the shots and he observes your client with a gun. Is that correct?
Well, not exactly. He's a mess, Clayton, in terms of his actual testimony, and he excluded him as far as being the shooter is concerned. So we have no...
Well, how does he exclude him from as being the shooter? Because my understanding of the testimony is that he hears the shots fired. He doesn't see who fires the shots, but then he sees your client with a gun.
Well, he knew Imbert, that's for sure. He said he heard the gunshots, and he never saw the shooter. That's clear as day, and that's on transcript page.
I totally get that. I'm just trying to understand that, but he says he sees your client with a gun,
I
right?
think he was equivocal about that, Your Honor. There's a lot of running, there's a lot of people moving.
Because I'm going to ask Ms. Campbell that, but so you think he's equivocal about that?
I do.
Okay.
But I don't deny, I could be mistaken again, I don't deny that there were one or two people that put a gun in my client's hand for an instant or two in this very fast-paced scene when there were all kinds of suggestive questions being thrown around by the police and all kinds of people running for cover. The reality, Your Honor, is this. Every single piece of evidence that was directed toward my client could almost equally have been directed toward Dapp, who's the guy we argue probably did it.
Well, but I think your sister in her brief, and I've not gone back to the transcript, says that Shane Clayton heard the gunshots before Dapp left the club.
She said that, and she probably found a site for it. You go through these 20 pages, 15 volumes, you can find a statement that someone said it, almost anything. And here's my point on that,
No,
Your Honor.
he also says that that Dapp is wearing a white T-shirt when a number of people say that the shooter is wearing a black.
Right, but other people put Dapp in black. So I think, Your Honor, the reality is this. I see my time is up. I heard what you said, Judge Kafter, but I think I'm obligated to.
Well, I have a couple more questions, so
Thank you.
you're going to get some.
I generally defer to my colleagues if they have
Well,
questions.
I just want the record to clear that I'm aware, and I'm happy to answer all your questions.
The record will so reflect.
Okay, so the spontaneous utterance, Dapp jumps into the car and says, drive off, because your client, Vega, just popped that dude.
Yep.
So I guess you're asking us, I believe, to change the law on
No.
this, okay?
No, I'm not.
But, okay, so explain to me how that's not a spontaneous utterance and how it's not, how it is testimonial, because
I'll waive the testimonial part for this argument, and especially with my red light on. I mean, there's good arguments that it's not testimonial.
Mm-hmm.
The spontaneity argument, however, stems from the fact that it simply wasn't spontaneous. There was a few seconds of time. And what you have to do is look at the totality. And the reason, as I know clearly that you've read it, I draw this distinction between victims who sometimes make spontaneous utterances that are admissible. In this kind of situation is the fact that it's a direct accusation of a third party. And all you have to do is be an amateur student of human nature to understand that, if I were to pull out a gun and plug somebody in the back, I could run out the door and claim somebody else did it by the time I got to the court officer. It's just human. Anybody who has a child, you catch a kid's hand in the cookie jar, you say, Fred, your hand in the cookie jar, they're going to say, no, it's Jake. Even with the hand still in the cookie jar.
But no one's accusing Dapp of being the shooter.
Oh, yes, we are. I am.
No, I mean when they walk in the car, they're not accusing him of being. When he jumps into the car, it's not as if, like you're hypothetical about the child answering mom or dad's question.
No, but he doesn't want to tell his friends he just plugged somebody, so he puts it on my guy. I mean, how hard is that? He goes running into the car. Vega just plugged some guy. Am my guy supposed to go to jail for life on that? That is simply not the kind.
So he's planning his defense the instant of the shot? Is that what we're...
No, because that implies court, that implies sophistication. He just doesn't want to say to his friends, I just shot somebody. It's much easier to say somebody else did it. And it's human nature, and it doesn't take any fabrication. It doesn't take a lot of instinct. And in this case, what's really tragic is that it's not true. And more importantly, Your Honors, you have to, at some point, I understood your question about testimony, I understood why you asked it. Right. I read Crawford, I've read all its progeny over and over again. But at some point, you have to ask yourself, do we believe in the Confrontation Clause or not? Because that's what underlines all this. How can we possibly be a jurisprudence that claim to believe that everybody has a right to confront the witnesses against them if this kind of statement, you can't get a more incriminatory statement used against someone than this kind of statement. Right. And it's absolutely hearsay, the rankest of hearsay. And I do ask you to draw the distinction between victims. I think it's an easy distinction to draw. You don't have to say there's a whole new kind of excited utterance. You just have to understand that the precedent that develops when the victims are bleeding and they also might need hospitalization and the police show up and they say, the old man smacked me, is not the same as some guy who's at the scene jumping into a car, putting it on his buddy. And we all know that the facts make the law as much as the jurisprudence itself, and I think if you look at it that way, it's an easy call, quite frankly. So as you know, there are a lot of issues in this case. I do see my time is up, and I would like to summarize 30 seconds, literally.
I'll give you the 30 seconds, but I got two questions before that.
I'll answer them. I'll take-
You challenge the accuracy of Judge Connolly's version of Vic's testimony in the missing transcript. Where do we find in the record what defense counsel claims to be the truer version?
Judge, we don't exactly, and I asked you to think back.
So how are we supposed to, what are we supposed to do
Well,
with that?
you're supposed to throw the conviction out on the grounds that my client's rights were lost irretrievably when this transcript
But you're
was
saying that Judge Connolly's version is inaccurate, but
No,
I
I'm
don't
not.
I don't see anything which says here is the accurate version so we can compare versions.
So here's the question you're really asking me. The government, and I'm talking about the institution, it's a first-degree murder case. They lose the transcript. The government, not any person.
Well,
Okay.
it's the court.
The defense counsel.
I mean, in fairness, it's the court reporter. I'm
All
not
right, but she
justifying
works
it,
for the
but
government.
It's not, she works for the court.
All right, so the court. The
Or
court
he, I don't know
loses
whether it's
the
a she or he.
transcript
But it's not the prosecutor.
of the key identifying witness, not just anybody. Not just anybody. The key identifying witness in a case where there's all kinds of bad stuff going on between counsel and court and everything else. We never have this. Then an appellate lawyer comes along, a woman named Stella Robinson, files a motion to recreate, which is what you're supposed to do under the rule. Mr. Greenberg says he doesn't have much memory, and the government and the court, put together this transcript that, lo and behold, the government is satisfied with. What we do have, and the only thing we have, is that Mr. Greenberg says, I made a ton of objections, and none of them showed up. Now, all you got to do is look at the rest of the trial and see that he certainly had a capacity to make objections.
Do we have a record of those objections?
No, the exact objections, no. He couldn't remember what they were. And I'm prepared to...
Does he have a record of what he said? Do we have any record as to what Greenberg is complaining about with regard to the transcription?
Not that I recall. Not that I recall.
Okay,
It was all
so-
done by Robinson later on, and Mr. Greenberg didn't really have much of a memory.
So
I can tell you this, too. I mean, we called him. I don't want to go extra record too far. I just think the poor guy, it was 3 years later, he didn't know there was no transcript. Don't forget, I mean,
I
the case...
understand.
The case is over. He files a motion to withdraw. It goes to appellate counsel. It's not till years later that he's suddenly confronted with, he goes, I know I made a lot of objections. And that's irretrievably lost, Your Honors.
Okay.
That's a due process.
I understand. Let me move on to my second question, which is you're complaining about Crump, and I don't understand. The defense investigator said he spoke to Crump by telephone, and Crump said that he was shown a photo spread and did not ID anyone. Was that before or after trial?
After.
That was after trial.
Yes. And by the way, here's an interesting little thought that we have not been able to get to the bottom of in my office. Ms. Robinson somehow looked at this transcript and instinctively knew there was missing discovery, because she filed a post-trial motion for this discovery. And giving credit where credit is due, I wouldn't be making this argument if that motion hadn't been previously allowed and this material that we were debating, the stuff I couldn't even read, hadn't shown up in my file, in 2012. But, people knew almost instinctively, and that's really where I want to end, Your Honor.
I'll give you your 30 seconds.
Yeah, the 278-33E. I suggest to you that Lieutenant Imbert is actually and factually innocent. And I think if you go, and personally, for what little it's worth, I actually believe that. I've sit with him. He's a sweet gentleman. He's had trouble in his life in the past, but he's waited for this day. And if you look at this record from start to finish, I've gone with your questions, obviously. This trial is a mess. And I'm including in that the fact that we're also missing the transcript of the one and only witness. And that gets back also to your Honor's question, Justice Gantz. Even if Judge Connolly is correct, in everything he said about Vic, she's only one witness, and she only saw it for perhaps a second or two. And all this exculpatory evidence was missing. And then you have the issue of the judge and the trial lawyer not getting along. Then you have the closing argument issue, which I couldn't even address, and I don't have time for, which I think is very real. So I think if you look at the totality of the circumstances, this case should be reversed just because it's a lousy record. However, The denial of exculpatory evidence is unequivocally wrong, and that gives you the tool to send this back and give us a new trial. And if there are no further questions, I thank you for your extra time.
Thank you. Ms. Campbell.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to affirm the defendant's conviction for the first-degree murder of Vaughn Skinner Jr. I'll start, I guess, with the record on appeal, and I'd like to clarify something my brother said. It's not that all of Ms. Vick's testimony is missing. It's just one day of it is missing, her direct examination. The end of her direct examination, and this is on volume 4 of the transcript.
It's the identification part, though, right?
Correct, and I think that is critical, but here's where I think that my brother's argument falls apart. Defense counsel, his method of cross-examination is to go through almost every single fact that Ms. Vick testified to, and so specifically as to key identification points, he goes through all of that, specifically on volume 4, page 71 of the record. So it's not as if we have a barren record with no testimony at all or no cross-examination at all. Defense counsel does go piece by piece as to what her direct testimony was. And that...
So when we read his cross-examination, we're going to see that she identified the defendant.
Correct.
And she also testified that the defendant called her up.
That's the only piece of information that she's not asked about on cross-examination is that call from the defendant in the aftermath of the crime. And if you look at my brief, I did try to cite the cross-examination where those facts came out in cross-examination, just so the court can see that it is supported on the record that the court has. But I'd say, even more importantly, when you look at that cross-examination and you look at trial counsels going piece by piece through what her testimony was, you see it largely comports with what Judge Conley found in his reconstruction. In fact, there are handwritten notes from Attorney Greenberg, and that's the only thing that was submitted. If you look at what those handwritten notes are, and I'm sorry, I don't have a record appendix page cite in front of me, but it is in the record appendix. If you look at the handwritten notations that Attorney Greenberg wrote, you'll see that he's disputing facts, and then when you compare it to the cross-examination, it's facts that he actually brought up on cross-examination. And so that is in the record for the court to see as well. But critically, her identification of the defendant as the shooter, specifically a lot of the questions that you were asking, Justice Kafka, of my brother, as to her positioning, as to where exactly she was standing, as to her ability to observe, those are all borne out on cross-examination.
So just so I understand, so Vick is driving the car away. What is her testimony about her observation of the defendant?
She is backing up. And when she hears the gunshots, she stops the car, she gets out, she goes to her trunk. This is roughly, I believe, this is all in volume 4, what I'm relying on the cross-examination, specifically page 60, starting on 62, on to, I believe, 71, where she talks about her identification of him. But specifically, she says she's in the car, her cousin Keisha Warner's in the front passenger seat. She's starting to back up, hears gunshots, and gets out. She goes to her trunk area, and when she is at the trunk area, that's when she could see the victim on the ground and the defendant standing over him, and that's when she sees a second round of shots that are fired.
And do we have any forensics which would corroborate what she saw in the sense of where the bullets were? How many bullets there were?
Not forensics, but you do have other witnesses that describe the same chronology and the same...
How many shots were fired?
I think... 2 bullets were retrieved from the victim's body. It's believed that there was a bullet that was shot towards the direction it hit a car. There was a shattered window of the owner of the club or the club promoter. So that supports at least 3. I think it varied in testimony how many gunshots the eyewitnesses heard, but it was in the 3 to 4 range. There were then shots that were fired in the direction of Corey Crump.
And it was a revolver, so there's no...
There's no shell casings.
And in terms of the description, she says that he was on the ground when the defendant was shooting, do we have any indication from the autopsy that the person was on the ground when the shots were fired?
Correct, yes, both from the autopsy, he never got up from the ground, he stayed on the ground. The shots were, I believe, in his chest and through his arm, so I don't think if we just had the shots, you could say trajectory-wise, there was no such testimony like that. But the positioning of his body is corroborative of that testimony. There's also another witness, Miss Sanchez, who describes a similar type of scenario, although she is not able to identify the defendant as the shooter, and she gives an inconsistent description of the shooter as a person with an afro, but otherwise wearing very similar clothing.
Is she shown an array?
Yes, she is shown an array.
So she's shown an array with the defendant and does not identify?
Correct.
So does that matter? So the jury is exposed to somebody in the same position as Ms. Owen, who doesn't identify the defendant, doesn't seem to make a difference to them.
Correct.
So,
So it wasn't as if the jury heard no evidence that there was a failure of any witness to make an identification. And it's not as if my brother harped on the evidence that was presented. It was admittedly a chaotic scene. It was a bar brawl that then came into a parking lot. People were in various stages of sobriety. People were at different vantage points. People testified as to the different things that they saw. What the important part is all of that evidence, including the conflicting evidence, was put before the jury. And my brother kept on, I lost count of how many times he said the truth in his oral argument, but it's not for defense counsel or I to determine what the truth is. It's for the jury to determine what the truth is. And the jury heard all this evidence, they looked at the evidence, and they weighed it the way that they saw fit, and they found that the truth was, and I'd say what the evidence supports, is that the defendant was the individual who shot the victim in this case. Now that leads me to what my brother spent most of his time talking about, which is the photo array issue. And the Commonwealth has never disputed that the failure to turn over Crystal Owens' photo array was not exculpatory. It obviously is exculpatory evidence that should have been turned over. That's been our position since day one. But that doesn't entitle the defendant to automatic reversal of his conviction. Instead, he has to show that there's a substantial basis for prejudice, which in this case is that it would have influenced the jury's verdict. Now, it does not for a lot of reasons, but primarily there was a lot of different identification evidence in this case. And what you have is you have people who knew the defendant, who identified him, mainly Miss Vick and Mr. Clayton. You have people who were just bystanders at the scene who didn't know it, who gave descriptions, and those descriptions matched both the defendant and his physical attributes and what he was wearing.
your brother argues that Vic, it takes her 4 times to get here. I'm not sure what he meant by that. And Mr. Clayton's also got some issues with his. Why don't you address the issues with their testimony?
Sure. The issues with those testimony is that they both didn't want to cooperate with the police because they had concerns. And I think when you look at Miss Vick, she was a young woman, and she was afraid of the defendant. She testified that he specifically called her in the aftermath, and I'd say it supports that he threatened her when he said, "I don't know you, and you don't know me." I think it's understandable that in the aftermath of witnessing a shooting, then someone calls you and makes a statement like that you'd be reluctant to cooperate with the police. Mr. Clayton had the same type of...
When you say reluctant, did she give statements inconsistent with her trial testimony previously?
She did insofar as she told the police that she didn't know, she didn't have any information to give them. I'm not recalling what her specific statements were to the police, but there definitely was evidence that she did not cooperate, that she was not forthright in the information that she had, and it was not consistent with what she ultimately ended up testifying to at trial. But that was brought out through cross-examination and was before the jury.
And Mr. Clayton, there's the issue of what Mr. Clayton saw and what he didn't see.
Yes, and I disagree with my brother's characterization there. And specifically, Mr. Clayton testified that he sees the defendant before the shooting, and this is on Volume 5, page 33, he says that the defendant was mad, he was angry at that time. That's also on page 33. On page 34, he says the defendant told him to get to a car because the man was over there. He says that 10 to 15 seconds later, he heard gunshots. And when he heard those gunshots, he ducked down. That's page 35 through 36. He said that he ducked down for approximately 30 seconds. And specifically on volume 5, pages 37 to 38, he then got up and he saw the defendant, and the defendant had a gun hanging from his left hand. And there was nothing equivocal or about that statement.
And here the bullets recovered, there's only one gun that's firing here, or are there different kinds of bullets here, or just one set of bullets?
Just one set of bullets.
Okay.
There is a 9mm, which is recovered when the defendant is arrested later, but that's a semi-automatic, and there were no shell casings found, so there's nothing to show that was shot. I think importantly, though, to get to why his viewing of the defendant and the gun was definitely not an equivocal viewing is then on page 38 through page 40 of volume 5. He specifically remembers that it was a snub-nose revolver, which was black or brown, and he says he's 80% sure it was a revolver. He's shown a picture of a revolver, and he says, well, I know it's a revolver, but it's not as long as that revolver. So this is not a witness who thinks maybe he saw a gun. He with specificity testifies about the gun that he saw.
Can you just refresh me on the breaking of the window and getting the gun and that issue, okay?
Yes, sure. I'd say what the prosecutor argued about that in his closing was supported by the record, and I would point to Clayton's testimony to support that point, specifically the chronology, that he sees the defendant in the vicinity of the car before the gunshots. Specifically, he says, on volume 5, page 46, when he first saw the defendant outside, the defendant's hands were in his pockets. And then he says...
So I'm confused, though. So there's blood on the window of the car, right? So someone had to break the window of the car to get the gun, is that right?
Someone broke the window to get the gun. It's unclear.
And Dapp's bleeding from his hands, right?
Dapp had been in a fight. There's testimony from...
Trying to understand, is
No,
there
I
any
understand.
blood on the defendant's hands?
There's no evidence that there's blood on the defendant's hands. I would say that what I would point to support the prosecutor's assertion that the defendant broke the window is Clayton's testimony about the chronology of when he saw the defendant, that he saw them near the car and he heard the shooting. He saw the gun in the defendant's hand. Volume 5, page 56, he saw after the shooting, Clayton sees that the window is broken in the defendant's car. So that temporal proximity. I'd also point to Elizabeth Marles.
No, there's no markings on the defendant's when he's arrested or anything, that he's got any cuts on his hands or anything.
He's arrested far after
Okay.
this occurs. But there's no testimony from any of the women who saw him that night that they noticed any blood. There's also...
So this is the defendant's car that the window's broken on, is that what you
Correct.
said? Okay.
Correct. But I would also point to...
Defense car, or is it Dapp's car?
it's the defendant's car that Dapp was driving that night.
And Dapp's, the keys were found in Dapp's sweatshirt in the club when Morell went back?
Correct. But there's also testimony, I think specifically from Trooper Murphy, that the car was registered in either the defendant's name or the defendant's mother's name. There was also testimony from people who knew the defendant that he was known to drive that car. There was testimony also from, I believe, Clayton, that they came that night and Dapp was driving the defendant's car, though it was the defendant's car. And I would also say that Clayton testifies specifically that Dapp was still in the club when the gunshots ran out. He had just gotten into an altercation and was on the ground.
And the testimony that how Dapp is cut, it's from the prosecution's perspective, it's because he's been in a brawl.
Correct.
Right. Okay.
Correct. I'd also say there's one more piece of evidence which supports that the defendant broke the window, and that's a conversation that was had with Elizabeth Marles the morning directly after the incident. And I'm sorry, I apologize. It's specifically volume 6, page 237. My brother points out to it in his reply brief and says that I misstated the conversation. The way that I read the context of Ms. Merle's testimony is that Dapp says that he had to break the window to get the guns. The he that he's referring to in the context is the defendant.
But it could be read to mean he, meaning Dapp, potentially.
Potentially it could. I think there's a fair reading that it also, the he is the defendant.
Do we have any in-court identifications in this case?
Yes, Ms. Vick.
By Vic, and is that in the record, or is that the part that's not in the record?
That's not in the record, though I believe that it's acknowledged by defense counsel on
Do we
cross-examination.
have any out-of-court photo spread given to Vic?
To Vic, yes, I believe so.
And is there an exhibit?
I would assume so, but I don't know the answer. I can get that for you, Your Honor.
But there was an out-of-court ID done with a photo spread. Was there any motion to suppress as to Vic?
I don't believe, this was also tried in 2000, the murder was in 2004, and I think it was tried in 2006, so this is.
Right, it was well before Creighton, I'm not saying that, but
Correct.
I'm saying, but there was no challenge to the fairness of the photo spread. That law was well established by then.
Yeah, and I don't believe that there was. I don't have any memory that there was. I didn't look closely at the motions to suppress in this instance, though.
But was there one?
My memory is that there isn't. I just don't remember.
Your brother, when Dapp jumps into the car and supposedly says the defendant popped him, whatever.
Correct.
There are 3 other people in the car, or a couple of other people in the car.
Yes.
And he says, his cites, but I read the cites, he says that the other people didn't hear anything else. But my understanding is the Commonwealth is asking very particularized questions.
Correct.
What's your understanding of what was asked those other people in the car? I couldn't follow the question that was asked by the prosecutor. It's like,
Sure.
don't answer this, but answer this kind of thing.
Well, I think I think the prosecutor was trying to not elicit other prejudice. I think the prosecutor was trying to limit the amount of hearsay through the
Okay.
question. Anytime you're asking someone about, you're in a car with other people and they were having conversations, you could be opening the door to hear a whole bunch of stuff that wouldn't be admissible.
So he gets it from Clayton, but then when he's asking the other people, he's not asking what they heard, except for, because I'm trying to understand.
Sure.
The defense argues essentially that the 3 other people in the car didn't hear the statement, but that wasn't quite the way I read. I don't think they were ever asked, were they?
I don't believe they were ever asked either.
Okay.
And I think specifically Zeke Pompeilis, he does testify that there were conversations going on. He doesn't get into the content of what those conversations were. As to John Vanette, I have my notes right here. The most that he testifies that he could hear talking on cell phones and conversations, but he doesn't testify to the content.
Okay.
That being said, what the court has to look at is look at whether the decision that the judge made was an abuse of discretion. And here what you have is what the Commonwealth would have, what the proponent of any excited utterance would have to show is a startling event, and that the statement was a spontaneous and not result of reflective thought to that event. You definitely have a startling event, you have a shooting. I think that the context in which this statement is made supports that it is not the product of reflective thought. I think it can be contrast from the cases that my brother cites on, specifically in the reply brief, he cites White, and he has the example of someone coming upon someone and that person saying, I didn't do it, that person did it. This is not that kind of statement at all. When you look in the context, you have a person running from a shooting, jumping in a car, and yelling, get out, Vega just popped that dude. those statements are nothing at all like each other. And I think when you look at both what the statement is, the context in which it's made, and the circumstances in which it's made, the judge was absolutely in his discretion to rule that it was an excited utterance. With my remaining time, I would like to urge the court to not use and exercise its discretion under 33E. I would say that though the trial judge and defense counsel had a contentious relationship, that it did not cross the line. I would say that given...
How much was in front of the jury?
Well, here, that's a good question. I would say that not that much of it was in front of the jury, and the parts that were because defense counsel repeatedly refused to come to sidebar. And so what was the judge supposed to do? I think this is an instance where you have a defense counsel that was acting absolutely inappropriately, that the judge couldn't even address his conduct outside the jury because defense counsel was refusing to stand up. He was refusing to come to sidebar. Even when he was at sidebar, when he didn't like the rulings the judge would make, he would walk away and then start addressing the judge, questioning his judgments in front of the jury. And I'd say that the judge would have been absolutely within his discretion to hold this attorney in contempt. He didn't. I'd say he showed considerable constraint given the reprehensible behavior that was displayed before him. And I'd say that to permit defense counsel to behave like this and then obtain a reversal is the very definition of absolutely unacceptable behavior that causes manifest injustice. And
Well, but the behavior of the defense attorney should not be, the defendant should not bear the brunt of that if there's error in the trial, just because the defense attorney was misbehaving. There are other ways to handle the defense attorney.
There are other ways to handle the defense attorney. I'd say that the judge here did not impermissibly handle defense attorney. I would specifically point, I think this case is on all fours with the Brown case, which I cite on my brief, which says that though the judge occasionally admonished defense counsel in front of the jury, where the judge gives a specific instruction that the jury is not to consider anything that the judge did and impute it to his thoughts on defense counsel's actions or the facts of the case or the like, that instruction was enough. The jury is presumed to have followed it to cure any potential prejudice. I'd also say that you can distinguish this case from cases in which reversal has been required because the judge was mainly speaking to defense counsel in his behavior. He wasn't speaking, I think the Schneider case talks about witnesses and commenting on the believability of witnesses. He wasn't commenting on any sort of evidence or the weight of the evidence or trial tactics or the like. And so I'd say, given what I would characterize as the judge's restraint and that specific instruction, that there's no basis to conclude that there's any likelihood of misjustice, let alone a substantial likelihood of misjustice.
Before you leave, with regard
Yes.
to Crump,
Yes.
my understanding of it is that defense investigator after trial telephones a person who he understands to be Crump. Crump says he was shown a photo spread, did not ID anyone, and the trooper's notes do not indicate that he was shown a photo spread. Do they indicate that he was not shown a photo spread? Do we have any, has the trooper been spoken to? Do we know whether there was a photo spread?
I don't believe that there was. I think Judge Roach's findings are important on that because she doesn't actually find that Crump was actually shown a photo array. She shows that someone purporting to be Crump spoke to an investigator. She also says that in the statement which Crump says that he's shown a photo array, he also makes a number of other inaccurate statements about the trial.
But apart from whether or not Crump was Crump, we should be able to ascertain from the trooper whether or not...
Sure, and it's always been our contention that he was not.
He was not shown a photo spread.
Correct.
And there's nothing to indicate that he did.
No.
And was there, I'm sorry, I should remember, was there an evidentiary hearing for the motion for new trial?
There was not.
So there was no opportunity to call that trooper to testify?
No, there was no opportunity. The judge looked at even if you were to, she did not make a finding that Crump was shown a photo array, but she said even if you were to presume that this is true, looking at the prejudice, the defendant hasn't met that basis. And she declined,
Isn't it strange that Crump wasn't shown in a photo array? He's shot. He says he got a good look at him. It just seems odd that they're not showing him that. So how do we know he wasn't shown?
based on my review of the file, I don't want to speak outside the record.
Right, okay.
But
Okay.
But if it went forth to an evidentiary hearing, I believe the Commonwealth could prove that he was not shown a photo array. I think also Crump was also a witness who did not want to be involved. And he testified at the grand jury, but they were holding, I believe, his car. So there was, again, a reluctance for a lot of witnesses to come forward and make identifications in this instance.
And is Crump's grand jury testimony part of our record?
I believe that it is.
Okay, thank you.
Thank you.